This is a stand your ground hearing. Now, these happen all the time in that crazy state of Florida. This one involves the former ballet dancer claiming self-defense in the death of her husband, 28-year-old Ashley Benefield. She's in the middle of a custody battle with the victim, Douglas Benefield, 30-year difference in their ages. She's 28, he was 58. That always works out. So they're fighting over the daughter. The shooting occurs. The victim goes to the home of his estranged wife on that day, September 27th. Neighbor calls 911 after the defendant told him she shot her husband after he attacked her. She's arrested on second-degree murder charges. After the victim died, he was shot twice. He died later in the hospital, shot in the back. Curious about that. So, Dave Ehrenberg is here. He's from that state of Florida. He deals with this stand your ground defense all the time, and we've dealt with it in many cases. So, give me your thumbnails synopsis of what that defense is and how it might apply in this case.
In Florida, you get two bites of the apple. You can claim self-defense, stand your ground, meaning you had a reasonable fear of your life. So you had to meet force with force. You thought your life was in danger and you had to fight back with force. Well, once the other person's shot in the back, that sort of works against you. The fact that there was no, what are they called, it's like scrap on her hands, which shows that they were not close to each other.
I think no stippling was found, so yes. There had to be some distance, I guess, then.
Right, exactly.
From the weapon and the victim.
Right, so there was distance, there was no evidence that he had a weapon, he was shot in the back, there was evidence that she was upset with him, she made claims that a judge previously found to be false, that she had no claims because she wanted full custody of the child.
Domestic abuse issues or something. Right?
Correct. So there's no evidence that she should have reason to believe that her life was at risk. And it is still up to the prosecution in Florida to prove by clear and convincing evidence that you weren't in reasonable fear of your life. So the burden is not on the defendant, it's on the state, which is really kind of unfair. And so then a judge makes a decision.
Says the state.
Right, well,
yeah.
Yes, exactly. But and then if she loses, then she goes to trial. So judges, though, even though you can totally take it away from the jury, judges are sort of reluctant, Flo, we've seen, to say, no, this is not even going to go to trial. So I suspect she's going to lose this because of a lack of evidence, and this needs to go to a trial. Judge isn't going to prevent that.
And ultimately, Natalie, the defendant still, as Dave suggests, gets that second bite at the apple. It's virtually the same defense, but instead of being, conclusive, a determinative decision pre-trial, you go to trial, you throw it out there. What's your thought on the physical evidence, at least as we know it now, in the self-defense context?
Sure. My understanding of the physical evidence as we know it now is if you shoot somebody in the back, it's very unlikely to be self-defense. And so obviously I'm in agreement that this at the stand your ground level, I don't think that she would be successful, but I want to see a lot more evidence produced if she's going to be advancing self-defense. Now, I know that the state, even at the trial level, has to disprove that, but I just don't see how you can shoot someone in the back in self-defense. And that beyond a reasonable doubt instruction that we give to jurors, there's something in there about you don't have to put your common sense aside in order to decide whether or not someone is guilty or not guilty beyond a reasonable doubt. And I feel like common sense would prevail in that case. And there's an abundance of motive for her to take her husband out, both financial and emotional. So good luck with that, is what I have to say.
Okay. Well, we'll see about that. The hearing is tomorrow. Obviously, the trial down the road, regardless, unless somehow the stand your ground defense wins the day tomorrow. Most folks, my esteemed panel, thinking, denied. So, yeah, exactly. That's the legal terminology there. But we see that all the time. Curtis Reeves was a stand your ground case, lost at the hearing stage, won at trial. Travis Rudolph lost at the hearing stage, won at trial. So it's always a very interesting wrinkle in those Florida cases. Okay, let's take a break now. We're going to come back more for you at Law and Crime. Stay right where you are.